Want to welcome to the program Illinois attorney Bill Howard. Bill, thanks so much, sir, for coming on Cam & Company tonight.
Well, thank you very much for having me.
You bet. All right, a lot of stuff going on in Illinois. In fact, we've had the past couple of days, two big decisions. Let's talk about what happened last week in the case Shepard versus Madigan, where a district court, in essence, said that the Second Amendment, the right of the people to keep and bear arms, stops at the front door of your home?
Well, that's pretty much what the decision was. By the way, I should note that within 24 hours of the decision, an appeal was filed, and of course we are going to be taking it up to the Seventh Circuit to get this rectified. But yes, that was essentially the decision, is that they construed Heller and McDonald thereafter to limit the right to keep and carry a firearm to the home. And, of course, it's our view that that is not what Heller and or McDonald stand for, and that there's other authority out there to support that the right extends beyond the doorstep.
Okay. Now, what's interesting? There are a couple of interesting things to me about this bill. One, there is just the argument itself that the right to keep and bear arms, that somehow bear arms related to carrying a firearm only in your home. There was another case out of Maryland. I know that's in another court of appeals, where the judge in essence said, no, Maryland's may issue system it doesn't pass constitutional muster because it denies people their ability to bear arms for no good reason whatsoever. So it looks to me like we may be seeing the formation of a split in the various circuit court of appeals.
Yeah, I would agree with that, and I'd also point out that the case you're referring to, Willard versus Brown, is out of Maryland, and what the court did there is they basically enjoined the state from enforcing the Public Safety Act of the Maryland Code, which conditioned eligibility for handgun wearing and carrying and for securing a permit to wear and carry on a finding that the applicant had a good and substantial reason to wear, carry, or transport a handgun. Now, that in Maryland is a statute that has a condition on the issuance of a permit. Here in Illinois, there's a complete abrogation, and maybe many listeners don't realize, but Illinois is the only state that has no mechanism for carry in the entire country. So, yes, when you look at Willard and you see that statute was stricken and enjoined from enforcement, where there is some carrying, you can see how further off the Illinois rules are that don't allow anything whatsoever, not even a shall or may carry permit. And I think that we'll see more and more decisions if Heller and McDonald are properly applied that will go that way.
Okay, now I'm looking here at a commentary by Eugene Volokh, who runs the popular law blog, The Volokh Conspiracy. And he said in the Madigan case, the court says, quote, laws that impact the right to bear arms outside of the home, the Seventh Circuit has determined that intermediate scrutiny would apply. See Ezell. And Volokh says, Professor Volokh says, I don't see how that's a correct reading of Ezell versus the city of Chicago. The passage that was cited says, for all other cases, however, we're left to choose an appropriate standard of review. From among the heightened standards of scrutiny, the court applies to governmental actions alleged to infringe enumerated constitutional rights. The answer to the Second Amendment's infringement question depends on the government's ability to satisfy whatever standard of means end scrutiny is held to apply. They go on to say, they talk about a form of intermediate scrutiny, but as Volokh says, the Ezell court noted, quote, intermediate scrutiny was appropriate in another case, the Scoyne case, because the claim was not made by a law-abiding responsible citizen as in Heller. So when we get into the standard of review here, whether or not laws can stand constitutional muster, is the court trying to lower the standard of review, the court in Illinois trying to lower the standard of review for these laws to make it easier for gun control laws to be upheld?
Well, I think that's the case, and I think it's not appropriate given the law. Let me give a little background on that because I think that's a very excellent point. The decision you were speaking to, Ezell, was essentially an attempt to ban any type of firing range within the confines of Chicago. And, of course, the argument of the plaintiff there was, how am I supposed to get properly registered and go through the training if I cannot get the training within the confines of Chicago because there's no firing ranges. So in Ezell, the Seventh Circuit confirmed that, in our view, that the Second Amendment is a fundamental right. And citing Heller, the Ezell court said that the rational basis test is out. And it also said that I think it's very reasonable to extrapolate from Ezell that strict scrutiny, the highest standard or the highest level of scrutiny, should apply, because there were many instances in its analysis where it extrapolated First Amendment principles and decision and rationale to the Second Amendment. It also made a very significant statement, which was that broad prohibitionary laws restricting the core Second Amendment right are categorically unconstitutional. Now, here in Illinois, we have a broad prohibitory law which restricts the Second Amendment outside of your home categorically. So I think it's clear that Ezell stands for the proposition that the Illinois statute is not constitutional, and I would suggest that Ezell also stood for the proposition of a heightened standard of scrutiny.
Okay, so was this a case with Shepard versus Madigan, Bill, that the court didn't want to get too far ahead of the Supreme Court? I mean, I know that in Heller and McDonald, never was there an issue of carrying outside of the home. We were simply talking about bans on handguns, and so the court didn't have to reach any issue or reach any conclusions about carrying outside of the home. I understand that there may be courts out there who don't want to get ahead of the Supreme Court, but was that what this court was doing, or were they ducking the issue instead?
Well, I don't want to categorize or characterize rather what the court was doing. I can say this: our interpretation of Heller and McDonald is based upon the exact language that's found in those decisions, and most of the folks who are against carry outside the home and expanding, in their mind, expanding Second Amendment rights beyond the home, state that the McDonald and Heller cases gave a ceiling, basically, for what the rights were, and that was in the home. But that's not what the decisions say. What the decisions say is that the Second Amendment secures an individual right to keep and bear arms, the core component of which is the right to possess operable firearms, handguns included, for self-defense, and the words are, most notably, in the home. Now, there's another excerpt from Heller which says that we are to use arms for traditionally lawful purposes, such as self-defense within the home. Again, this is an indication of a minimum, not of a ceiling. And there's other discussion within the decision that talks about the ability to keep and carry. Now, there's also references to 18th century decisions, 19th century decisions talking about the constitutional rights that were involved at those times, which protected the right of citizens to bear arms in defense of themselves and in defense of the state. Now, of course, you don't defend the state just toting your gun from room to room in your house, and you also don't defend yourself only in your house. One could easily argue, it's just empirical fact, that the risks associated with defending yourself are exacerbated when you leave your home. Mm-hmm. So if you apply the very language that the court was using, I think there's ample authority in those decisions for the right of keeping and bearing arms to go beyond the home.
All right. Now, as you said, this case is being appealed. What's the timeline look like for this? When will we expect the first round of filings at the appeals court level?
Well, we'll be filing with the original appellant brief on our side within the month, and we are hoping that the respondents will file timely. I mean, it's possible we could have this teed up before the Seventh Circuit by the fall. That's our hope, and we're going to push for that to obviously to make sure that the rights of Illinois citizens are protected as best as they can be. Absolutely.
And I got to say, Bill, I mean, with the Illinois State Supreme Court decision remanding the case challenging the Cook County quote-unquote assault weapons ban back down to the trial court level to reconsider Second Amendment issues, It seems like Illinois is quickly becoming a real battleground state as far as Second Amendment litigation goes.
Well, I think it has been a battleground for many for a long time because it is the only state that does not have any form of carry at all. And I think it's percolated to the top, if you will, in terms of activity because of that very fact. The other case you're referring to, Wilson versus Cook County, it has been remanded. There's really no way to tell where that will go.
Mm-hmm.
But the court is asking about, or did direct the lower court to look at empirical issues about whether, in fact, there is any benefit or nexus between a lack of handguns in a specific area and a reduction in crime. Interestingly, we were talking about Ezell before, and it's pretty clear from Ezell that there has already been a discussion about some of these issues, and the Ezell court hinted that there's no indication that firearms bans actually reduce crime. And there's also authority in McDonald, as we go back to McDonald and in Heller, where the Supreme Court cautioned very carefully that you can't really apply an interest balancing approach here with such fundamental rights. And it also went on to say that the very enumeration of rights takes out of the hands of government, even the judiciary, the power to decide on a case-by basis whether the right is really worth protecting. So I think we already have ample authority in Heller and McDonald and Ezell that says that this interest balancing shouldn't take place and the right must be protected.
All right, talking with Bill Howard, Illinois attorney. And Bill, thank you again, sir, for coming on the program tonight. Look forward to doing this again soon.
Thank you for having me. Appreciate it.
You bet.